from religious leaders and Christians who launched nationwide prayers for his release. He only appeared after some time in court and charged with money laundering. In January this year, security operatives raided the homes of two deputy presidents of the National Unity Platform for Northern and Western Uganda, Dr. Lina Zedriga and Jacqueline Tumushabe. For weeks, relatives and NUP leaders did not know their whereabouts until they both appeared in court on the 6th of February in Gulu and Ndora, respectively. While others have appeared in court or released without any charge, some other citizens like Sam Mugumya, a former personal assistant to Dr. Kanokiza Besigye, who was taken on the 26th of August 2025 from a hotel in Nyamitanga, Mbarara, has not been cited to date or his whereabouts known. The latest incident involving former Kampala mayor and lawyer to Dr. Besigye, Arias Lukwago, has renewed concerns among rights advocates who argue that the repeated use of military-style operations against civilians points to a troubling trend.
But the fact that we continue to witness these arbitrary arrests, arbitrary detentions, indicates that there seems not to be a serious commitment of government to the question of human rights.
Sewanyana warns that the growing use of force by security agencies reflects a dangerous culture of impunity.
Why is government silent about these arbitrary arrests, detentions, and sometimes abuse that goes beyond reason? So, as Ugandans, we need also to be mindful that it is very possible that this abuse that continues to find room in every aspect of our lives will one day cause mayhem.
Human rights defenders say the recurring incidents appear designed to instill fear among opposition supporters, lawyers and activists, while security agencies maintain that their actions are intended to preserve public order and national security.
A sense of fear among those who have stood up against abuse. A sense of fear among lawyers, among opposition activists, among human rights defenders, and also a strong feeling that they are untouchables, that there are people who cannot be touched by the law, who are not held responsible under the law, and as such can act outside the law.
He argues that maintaining internal security is primarily the responsibility of the police and cautions against the increasing deployment of military tactics in civilian matters.
In our view, is not only unfortunate, arbitrary, but also augments our current thinking that there is a growing culture of impunity.
The Ghana Human Rights Commission says it is already engaging authorities over the latest incident, as Director, Complaints, Investigations and Legal Services, Pauline Nansamba, explains.
We have been engaging with authorities to better understand the circumstances around what happened. On our part, this is an ongoing intervention, so I would not like to comment so much, just to let the public know that we are engaging at the highest levels, and when we are in a position to give a clearer picture of what happened and what the circumstances are, we will be communicating that.
She adds that the law clearly outlines how arrests should be conducted.
To us, of course, there's the Police Act that provides that framework. We have the Criminal Procedure Code Act. We have the Magistrates Court Act. All of these laws provide for, actually, even a fellow civilian may, in certain circumstances, restrict someone if there is anticipation that a crime has been committed. But the preserve of arresting civilians rests with the police.
Despite criticism directed at state institutions, the Human Rights Commission insists it will continue speaking out.
But as a national human rights institution with a constitutional mandate that is clear, I would not say that we are afraid. I believe we have a mandate to speak out on any human rights issues and advise on how better we can ensure that we have rule of law and due process in the country.
Religious leaders like Pastor Martin Tempa have also joined the conversation.
In a country that is on the rule of law, this should not be happening.
He emphasizes the importance of respect for constitutional rights and adherence to the rule of law.
Currently, there is a violation of the rule of law. There is a removal of human dignity, a violation of human rights of what we see.
Although government and security officials have previously defended such operations as necessary for maintaining law and order, concerns over legality, accountability and respect for constitutional rights continue to be raised by rights groups and opposition leaders. I'm Benjamin Jumbe, NTV Tonight.
Former Kampala Lord Mayor and Advocate Elias Lukwago is facing 1 count of misprision of treason before Makinde Chief Magistrates Court. Following his remand to Luzira Government Prison, court directed prison authorities to ensure that he receives specialized treatment at Mulago National Referral Hospital. Appearing before Magistrate Aisha Nanjara via Zoom from Luzira Prison, Lukwago informed court that his health continues to deteriorate despite receiving treatment.
I will have again to raise my legs up so that as I sleep, so that blood flows, to ease blood saturation. For now, they recommended specialized diet, which can help me manage, but I can't afford it. I cannot have it here. If no rescue is made to get my situation addressed, as advised by the consultants from Lago, it's a death sentence for me.
He also told court that he suffers from chronic lung complications that make his breathing difficult.
No doubt I'm a known case of hypertension, and this problem gets worse with all these complications, the cocktail of these health challenges. In the end, they complicate the issue of hypertension. And the cardiologists have also advised, if I continue with this sleeping posture to contain the issue of GERD, gastroesophageal reflux disease, then it affects blood saturation.
Medal Lubega Segona, lawyer for the accused Elias Lukwago, asked court to direct prison authorities to release the pillow to Lukwago's family so that it can be repaired. He urged that any further delay could put Lukwago's health at a greater risk. Court had also had a medical report from Mulago National Referral Hospital dated June 30th, 2026 and had been prepared and submitted for consideration. Regarding Lukwago's health, prosecution did not comment on Lukwago's health concerns, but informed court that investigations are still ongoing and requested court for more time to complete the inquiries. Magistrate Aisha Nanjara, sitting in for Magistrate Salaba Semera, adjourned the case to 16th July 2026. Deborah Namamonde, Viola Nansubuga, UBC News.
In order to have your document brought to the president, you can imagine, in order to have your document brought to the president, you had to pay a bribe of 30 million shillings. Mkama reported the matter to me. We arrested the gangs. There is therefore a count offensive against corruption, crime, and impunity. To show the impunity, take the case of Besigye, Dr. Besigye. He was arrested on the 17th of November 2024. It is now almost 2 years. All this time, however, he has been refusing trial, misusing the legal system. Why would this great Democrat and human rights fighter spend so many calories on refusing to come to trial, where he has got opportunity to prove his innocence and expose the undemocratic behavior of the dictatorship of Museveni and his family? What is the problem? Because the dictatorship of Museveni and his family is imprisoning Besigye wrongly. Come to the court and expose it. Why do you spend so much time avoiding court? Second question, why should the legal system for so long allow an accused person to just refuse to be tried. Somebody who's accused says, I don't want to be tried, and he's not tried. Is that a good system or what? How can somebody who's accused say, I don't want to be tried, and 2 years is not tried? This allowing of impunity to continue for so long is responsible for the culture of mob justice. Before you talk about the security forces, talk about the population. Why do the population take the law in their own hands? Why? Why do the population take the law in their own hands? The population suspects that the police and the judiciary may not hold the criminal accountable, hence the mob justice, which is unfortunate. The fascist tendencies among some of the elements of the opposition have for a long period provoked the patriots. See again, when in 2020, the rioters were undressing women because they were dressed in NRM colors. Let's see whether these people have the video. Freeze that, freeze it, bring it back, where the guard is undressed. Bring it back. When she's actually undressed, a bit forward, you idiot. This is, freeze it there, freeze it there. This is democracy. This is democracy. This is human rights. See, the woman is undressed because she had colors of NRM. And nobody.
The images of armed men, often in civilian clothes or military attire, descending on homes, especially of opposition politicians or activists, have become familiar in Uganda's political landscape. The latest victim is former Kampala Lord Mayor Erias Lukwago, who was forcibly removed from his residence by heavily armed operatives on Monday morning. For many observers, the incident is not isolated. On the 28th of December 2021, writer and human rights activist Kakwenza Rukirabaseja was produced before Buganda Road Court and remanded to Kitalia Prison until the 21st of January 2022 after he pleaded not guilty to 2 counts of offensive communication. This came after days without his family or lawyers knowing his whereabouts. Once he was granted bail, he decried what he called torture by security personnel who had held him. In March 2022, through his lawyers Kiza and Mugisha Advocates, Kakwenza filed a case in the East African Court of Justice seeking compensation for what he called torture and illegal detention meted out against him. In March this year, questions were also raised when security operatives stormed the home of activist Norman Tumihimbise in an operation described by some stakeholders as excessive.
If the operation was official, then they are cowards. Because you can't put on a pistol these young girls trying to ask. Even they asked about the way to the ceiling. So this is people's army.
Over the years, numerous supporters of the National Unity Platform have reported being abducted by unidentified security operatives held incommunicado, with some later only appearing in court, one of these being Eddie Mutwe, who was the party president Robert Chagulanyi's bodyguard. In October last year, 2 Kenyan activists, Bob Njagi and Nicholas Oyo, were taken by security operatives and held incommunicado for over a month before being released without charge. While initially security had denied knowledge of their whereabouts, President Museveni came out revealing where they were.
They had come to train our people. Of course, with our very good intelligence system, we picked them up. And they have been in the fridge for some days.
In December 2025, Masaka Catholic priest Father Deusdedit Sekavira was taken by men in army uniform, prompting condemnation from religious leaders and Christians who launched nationwide prayers for his release. He only appeared after some time in court and charged with money laundering. In January this year, security operatives raided the homes of two deputy presidents of the National Unity Platform for Northern and Western Uganda, Dr. Lina Zedriga and Jacqueline Tumushabe. For weeks, relatives and NUP leaders did not know their whereabouts until they both appeared in court on the 6th of February in Gulu and Ndora, respectively. While others have appeared in court or released without any charge, some other citizens like Sam Mugumya, a former personal assistant to Dr. Kanokiza Besigye, who was taken on the 26th of August 2025 from a hotel in Nyamitanga, Mbarara, has not been cited to date or his whereabouts known. The latest incident involving former Kampala mayor and lawyer to Dr. Besigye, Erias Lukwago, has renewed concerns among rights advocates who argue that the repeated use of military-style operations against civilians points to a troubling trend.
But the fact that we continue to witness these arbitrary arrests, arbitrary detentions, indicates that there seems not to be a serious commitment of government to the question of human rights.
Sewanyana warns that the growing use of force by security agencies reflects a dangerous culture of impunity.
Why is government silent about these arbitrary arrests, detentions, and sometimes abuse that goes beyond reason? So as Ugandans, we need also to be mindful that it is very possible that this abuse that continues to find room in every aspect of our lives will one day cause mayhem.
Human rights defenders say the recurring incidents appear designed to instill fear among opposition supporters, lawyers and activists, while security agencies maintain that their actions are intended to preserve public order and national security.
A sense of fear among those who have stood up against abuse. A sense of fear among lawyers, among opposition activists,
audience joining us across the various digital platforms of Zoom, YouTube, and X, and Facebook, and all citizens committed to the promotion of constitutionalism and the rule of law. I warmly welcome you to the 23rd edition of our Rnblive 2026 weekly hybrid press and public engagement of the Radical New Bar. I am by the name Robert Benon Jurua. I am a rule of law and litigation officer in the rule of law department at the Uganda Law Society. It is my very humble gratitude to welcome you to this edition, and I will be taking the honor to host you in this occasion and see to it that we have a seamless flow in our deliberations. As we are all aware by now, the Radical New Bar has always hosted this dialogue, which of course we can since realize that is given to us by the mandate in section 3C and D of the Uganda Law Society Act, in which we are mandated to ensure access to justice in all forms possible. And this one particularly is to regard the access to information right, as well as access to justice, in which we have meaningful discussions. The Radical New Bar, of course, was also established on the conviction that the ULS must not only defend the legal profession, but must also create a safe informed and independent civic space where very difficult national questions can be discussed openly, respectfully, and constructively. We do this every Thursday, and we're very honored to have all the members, especially those that are joining us online, together, because today and this time around we're having a hybrid session, which is also in the execution of the radical new bar tenet of digital transformation to ensure that justice reaches everybody regardless of your location in your place of comfort. Today, we're going to have a very interesting topic to discuss, but before that, we are going to go through the program that is going to be read out, and we shall be inviting the participants to partake of what is required so that we can delve into the different topics, or rather discussions to be had. We shall start our day with an opening prayer. Thereafter, we shall be listening into remarks from the Chief Executive Officer, Ms. Christina Wari. And thereafter, we shall be listening into a preamble of the discussion that is going to be held. And thereafter, we shall be listening into remarks from the Acting Secretary General of the Uganda Law Society, Mr. Babu Sali, who will also read out unto us the Executive Order number 12 that was recently released under the guidance of the Governing Council of the Radical New Bar, under the leadership of Isaac K. Semakade Senior Counsel. And thereafter, we shall be listening into a statement in reaction to the President's State of Nation address, especially in regard to the issue of bail. And thereafter, we shall be listening into reactions from the different attendees of this call, lawyers and all general members of the public who are on this call. We shall be listening into reactions from the statements that shall have been read. And thereafter, we shall be listening into our panelists who shall be told unto us in the remarks of the CEO, having laid the protocol. And thereafter, we shall be getting into a session of question and answer in which we encourage all the members on this call to actively participate, because the matters that we keep discussing on this call are very pertinent and they affect all members of the society, regardless of whether you're a lawyer or anything else. And thereafter, of course, we shall be coming into the close of the session, and we shall have some closing remarks from one of our council members that shall be on call, and we shall eventually identify that individual as the time goes by. Thank you so much. We would like to straight away delve into what we want to start with, which is the opening prayer. I'm going to call one of our colleagues, Ms. Gwenny Patience, who is also a rule of law officer in charge of research, to open the day with an opening prayer so as the Lord can come into this building. Thank you. Ms. Gwenny? I'm sorry, I don't know if she has speaking rights. Sorry, I see she's not having speaking rights. I don't mind praying as we go by. I know the IT department is still working on something. I think she will come on later. I would like to request us to humble ourselves for prayer. Heavenly Father, in the name of Jesus, we'd like to thank you so much for today, and thank you for the grace that you have provided for us. We thank you for this day that is starting. We bless your name, King of Glory, for this far that we have come, and we ask of you, King of Glory, to bless us with knowledge, wisdom, and understanding, especially as we delve into this topical discussion and also deliberate about the things that are affecting our country. King of Glory, would like to thank you for the leadership. Would like to thank you for our individual selves, King of Glory, and all those that are on this call and are representing different families, King of Glory. We pray that you will meet us at our various and different points of need, such that you could give us a peace of mind that is beyond imagination, King of Glory. We also want to thank you, King of Glory, for the Radical New Bar and the Governing Council for this time that we are alive, in which we're experiencing quite a number of things, but also very importantly, concern for the general members and also the members of the Radical New Bar or the Uganda Law Society as a whole, King of Glory. As we get into these discussions, Father, we'd like to pray that you'll give us the patience and the wisdom within which to operate in your realm, Heavenly Father. May you be in our presence and may you use us to reach out to people and cause a change or an impact that is necessary. We pray this believing and trusting in Christ Jesus our Lord. Amen. Thank you so much for that. We are very sure that the Lord is in this presence and would like to easily delve into the next agenda item, which is remarks or opening remarks from the Chief Executive Officer of the Uganda Law Society, who is going to be ably represented by the Head of Department Rule of Law, Ms. Afra Apio, who is online and is easily going to read them out and to us. I'd like to welcome Ms. Afra Apio to the call. I thank you.
Thank you, Robert. Our distinguished guests today, Mr. Godber Tumushabe, Mr. Kalali Stephen, the Uganda Law Society Governing Council, our colleagues and members of the Uganda Law Society, ladies and gentlemen, joining us on our various online platforms, good morning. My name is Apio from the Head Rule of Law. I bring you warm greetings from the CEO, Ms. Christine Nawari, who is unable to be with us this morning. My chief task this morning is to read her opening remarks verbatim, and I shall proceed to do so. I welcome you all to this week's Radical New Bar weekly press and public engagement, our platform dedicated to fostering informed public dialogue on legal, constitutional, and governance issues that shape our nation. Today's discussion comes at a particularly significant moment. On 4th July 2026, His Excellency President Yoweri Kaguta Museveni addressed the nation on a number of issues touching on the administration of justice, including remarks on bail, criminal trials, and the broader justice system. The address has generated considerable public debate among lawyers and citizens countrywide. Under the topic, Who Decides Justice? Interrogating President Museveni's 4th July 2026 address to the nation. We shall critically examine these issues through the lens of the Constitution, the rule of law, judicial independence, the protection of fundamental human rights, and the access to justice. Our objective is not merely to react to current affairs, but to encourage an informed, balanced, and principled conversation on the respective roles of the executive, the judiciary, and other constitutional institutions in the administration of justice. In our second segment, we shall hear from the ULS Governing Council on Executive Order Number 12, Abolition of Colonial Court Culture, including its rationale, implementation, and its implications for the society and its members. This will provide an opportunity for members and the public to better understand the Council's recent decisions and the direction being taken by the society. As today's Rnblive is being held entirely online, we encourage all our listeners who wish to contribute to the discussion to join us via Zoom. This will enable us to grant you speaking rights so you can share your views and engage directly with the speakers. The chat option is also open for all listeners to share their questions and comments. Thank you once again for joining us, and welcome to this week's RNB Weekly Press and Public Engagement. Thank you for your kind attention.
Thank you so much, Ms. Afra Apio, Head of Department. We are delighted, as always, to hear from you. We also want to thank the CEO for those very warm remarks that have always set the pace for us to discuss, of course, and also pass on our regards and love to her, because as usual, she is a mother and she always gives us warm regards. But as you have noted, as we proceed with the program, there is a lot that is up for discussion, and it is not just going to be a discussion around bail, particularly because the president, if you've noticed, of course, speaks about so many issues, and we're going to have members discussing about all these things. Among these issues, of course, there's been a lot of intense debate because of recent, if you've noticed as well, there's been so many developments that have come up about the infringement of different rights, especially those to the press freedom and association, and generally the administration of criminal justice concerning various individuals that, of course, are notable. Very many of them are public figures, and we've had the chance as the Uganda Law Society to be in the thicket of it to ensure that we are seen to stand tall, but also see to it that we support the members of the public or members of the bar, which, of course, is our cardinal role as the Uganda Law Society. So this discussion of the president or the address has occupied Uganda's legal, in a way, political and constitutional discourse, but also it has been the case for so many years, because it raises very difficult questions that go beyond whether an accused person should be released before trial. It invites us to ask very fundamental constitutional questions. For example, who determines the content of justice? Because if he's mentioned in his statements that we shall eventually hear, and a video was played just before we joined this call by the IT department on what specifically he was speaking about, who really determines fundamental constitutional questions? Who determines the content of justice? Is justice defined by public opinion? Because if the inmates or the suspects or the accused are said to tamper with witnesses, is that speculatory, or is that a fact which can be proved in any way for you to base on such reasoning in order to deny somebody bail? Which of course means that there is a lot of desire to see to it that we have the right questions answered. And maybe another question: where does the separation of powers begin, and where does it end when the different arms of government are expressing different views on the administration of justice? But also very deeply concerning is, where is the judiciary in all this that is being mentioned? If the executive, the head of the executive, is making such statements, and we don't have any, okay, as far as we're concerned, as far as I'm concerned, I haven't seen a statement from the judiciary which is tackling very, very critical issues that affect the judiciary. So yeah, these are not just necessarily abstract questions or the academic questions. They affect every Ugandan, because every citizen may find him or herself in such a very critical place where you're going to require the protection of constitutional guarantees. And the Constitution was deliberately designed to ensure that liberty is not surrendered to emotion, popularity, or political convenience, because clearly the people that we're talking about who are under incarceration are members of the opposition, which of course leaves a lot to be desired. And we have also realized that there are scenarios where different other different political actors aligning themselves with the ruling party have since faced the wrath of the law, but at the end of the day, we've seen that they've either come away scot-free or have been, cautioned or given a tap on the wrist, which leaves a lot to be questioned by the public. And at the same time, the state is easily either covering up or finding a way to make that person or that individual's crime look much more easier, much more smaller, which of course is a lot to be discussed. So we are therefore looking at legal and necessary discussions to be held, and the proposal touching bail, judicial discretion, or criminal procedure needs to be examined very, very critically through the lens of constitutional supremacy, judicial independence, and human rights, the human rights discourse. This discussion is not really about personalities, like I've said. It's very important for us to look at it from the angle that we're all citizens, and anytime any of us can easily fall in one of these holes that require you to exercise your constitutional right. And it's not about political allegiance. It doesn't matter whether you are aligning yourself to the ruling party or otherwise, as long as you're a citizen that bears who has a national ID and has a NIN, it is easier for you to, you're supposed to stand up to that occasion. And the state, as a duty bearer, is supposed to give the best of service as it is written in the Constitution. So it's not about defending or attacking any institution of the state. We are simply speaking hard facts that we all know are not very easy to be taken on by anybody. It's really about strengthening constitutional democracy by encouraging informed dialogue like this one we're having, grounded in the Constitution, statutory law, and established principles of justice. As the Uganda Law Society, we believe that disagreement should be answered with reasoned argument. The reason we have these discussions, and we always host very, very credible and astute either lawyers or members of the public, depending on the question that we are discussing on the day, who really give reasoned arguments, and it's also showed by the participation and the continued call for discussion, because many a time we get calls from the general public about matters that need to be discussed. Very recently, we must also let you know, there was a very critical issue about DNA, the technology of DNA and fatherhood. We are still in the kitchen trying to cook something about how to bring that issue up for discussion, because you remember a very famous singer, the late Paul Kafero, was in the domain, in the social media domain, being discussed about what happened in regard to the results that came out after it was taken for paternity tests, and very many children were denied, and yet the individual is deceased. We're talking about maybe the mothers who are now there to prove for us, but that is another topic for another day. Tonight, we are therefore going to try to interrogate the legal implications of the president's address, examine the constitutional architecture governing bail in Uganda, and consider whether reform is necessary regarding how bail is being handled. It's a discussion we've always had for time immemorial, ever since both the governing council and also councils before that have been established, and want to explore whether these reforms would require a little bit of dialogue and referenda, because this is a very critical matter. Yeah, so the members on the call that are going to speak to us are going to have their insights, but also before that, we're going to listen into the Acting Secretary General of the Uganda Law Society, who is going to read out unto us a statement, the executive order, which was released this week, and we want to put it into perspective in order to understand how the tenets of the radical new bar dealing with decolonialization, demilitarization, democratization, and of course digital transformation have been embedded in the period of time that the radical new bar governing council has been in place, in order to give us a feel and a platform and a basis and a foundation of the topical discussion up for today. I would like to know if we have the Acting Secretary General of the Uganda Law Society online, if they are kindly unmute and help us join the call to read out the statement, please. Okay. It appears we don't have the acting
Hello,
secretary.
am I audible?
Oh, yes, you are, Mr. Babu, loud and clear. Would like to indulge you to engage the members on the call, kindly. Thank you.
Okay, that's fine if I'm audible.
Yes, you are.
Yes, good morning, members. Thank you for all those who have endeavored to be online, because as we are aware, there was a communication and an order to the effect that I would be working remotely, and that has applied to all of us, inclusive of the council members and the staff, except those in the crucial area of our legal aid project who have the duty to meet members of the public and those who have concerns on a daily basis. Thank you, Jurua, for calling me up to take members through the executive order, RNB number 12 of 2026. This was one that was delivered on 7th of July 2026. That is a few days ago. That's about 2 to 3 days ago. And here it reads, abolition of the colonial court culture. Whereas today marks Sabasaba Day, that was the insult day, the East African commemoration of resistance against authoritarianism, the unity of purpose that forges a nation, and the unyielding demand of the people for civil liberties and justice. Whereas the judiciary is in an appalling state, marked by executive capture, chronic delays, selective justice, prolonged pre-trial detention, judicial corruption, systemic bias towards the powerful and connected, and deliberate unresponsiveness to enforced disappearances, torture, and attacks against lawyers. Whereas the military routine subverts judicial independence through illegal arrests, extrajudicial searches, detentions, and executions, court invasions, obstruction of lawyers and journalists, and the trial of civilians in military tribunals. Whereas these failures have been shielded and perpetuated by an archaic culture of ritualized civility, including bowing, scrapping, and the compulsory use of feudal and colonial honorifics such as my lord, your lordship, my lady, your worship, and the like titles that elevate judicial officers above citizens who are in reality their employers. Now, therefore, upon consultation with the governing council of the Uganda Law Society, and in the spirit of Sabasaba resistance and the radical new Bar's commitment to decolonizing justice and restoring dignity to the people, it is hereby ordered as follows. 1. Abolition of deference rituals. The practice of bowing or any other form of physical subservience before judicial officers is henceforth prohibited for all members of the Uganda Law Society. 2. Abolition of feudal honorifics. The following titles and forms of address are abolished with immediate effect. Your lordship, my lord, my lady, your ladyship, your worship, and any other honorific that implies lordship, worship, or feudal superiority. Judicial officers shall be addressed plainly and equally as Mr. Justice or Madam Justice for the members of the Supreme Court and Court of Appeal, Mr. Judge or Madam Judge for members of the High Court, Mr. Magistrate or Madam Magistrate, Mr. Registrar or Madam Registrar, or simply by their surname where appropriate, for example, Judge Okello, Registrar Ankunda, or Magistrate Nakato. Plain speech and equal dignity. All advocates and litigants appearing before any court or tribunal shall stand upright and speak as free citizens. No member of the radical new bar shall enforce or observe rituals that force Ugandans into postures of humiliation as the powerful enjoy comfort and deference. 4. National consultation on court culture and clan charter. Recognizing that the full decolonization of judicial costume, language, and service standards must reflect our history, climate, and diverse practices, the legal profession shall commence a public consultation on this matter within 90 days. The consultation panel shall comprise representatives of the bench, the bar, and citizens' associations. The consultation shall A, review and report on the continued use of colonial wigs, gowns, and foreign language requirements with a view to adopting dignified Ugandan alternatives that uphold equal dignity and public comprehension, and B, review, redraft and decolonize the judiciary client charter to ensure it is written in plain language, reflects Ugandan realities, and guarantees citizens' rights to respect, information, time-bound service, and redress without deference or cost barriers. 5. Purpose. This order shall strip away the theatrical props of elitism that insulate judicial officers from the daily discomfort, frustration, and powerlessness experienced by Ugandans in the justice system. By removing these barriers, we force the powerful to confront the humanity and dignity of the people they serve or fail to serve. 6. Publication. This executive order takes immediate effect across all members of the Uganda Law Society. It shall be published immediately on the Uganda Law Society website and circulated via official email to all members. Issued under my hand this 7th day of July 2026, signed and sealed by SC Isaac Chimaze Semakade, President and Head of the Bar. That is it. Thank you. Jirua, you can take over, please.
Yeah, thank you so much, Mr. Babu, for that eloquence and an unequivocal message that has been sent both to the members of the bar, especially, but also to the general public, and the message behind it. I don't know if Mr. Babu can give very few highlights of what he imagines about that statement, because it has been widely shared. It has gone continental. It has actually gone worldwide, and we have gotten messages for those, of course, who know us from very far away about the statement. It has gone into the dailies, and it has sparked a lot of debate, including our sister bar in Kenya. There's been a lot that has been said about the statement, and it is a message to us, especially in regard to executing the tenet of decolonization, and it is something that we want to unpack and get a feel about. But now we want to juxtapose that statement with the next incoming statement, which is going to be read out unto us by one of the staff at the Secretariat of the Uganda Law Society, which is in regard to the remarks made by the President of Uganda, that is His Excellency, the President of Uganda, Mr. General Yoweri Kaguta Museveni. But we have a response from the head of the bar, the national bar, that is the same author for the statement read out by Mr. Babu, in regard to what he said in his statement to the nation. Mr. Babu, do you have any a statement to make about what you just read out? What is your analysis and feel and whether it is necessary and whether it's a necessary moment to divert from what the colonial times have been offering us, in which we have been bowing and regarding these judicial officers with such high class names, and yet we are also seeing that there's a lot of diversion from the levels of integrity, the much of them being gullible and susceptible to pettiness, so to speak.
Okay.
Yes.
Thank you. I hope I'm audible. And to begin with, you have said part of the ideas that drove or that spoke to the release of the Radical New Bar Executive Order number 12. One, decolonization is one of the pillars upon which the Radical New Bar stands. As we are all aware, it's driven by the 4Ds that we intended to implement and that were timely for all Ugandans to embrace. The spirit behind this executive order is one that is visible, is one that we are living with currently, and you've spoken to a few of those. For example, the practice of bowing. The practice of bowing is one that gives judicial officers an elevated kind of physical subvergence above the ordinary Ugandan, and yet at the same time you find that it gives them the godly-like authority. The power is in their hands, and yet it is the opposite, that they derive the power from Ugandans. The power given unto them under Article 126 is derived from the people, and therefore the act of bowing is one that is not in conformity with that power or with the rights and the values and aspirations on which they derive their mandate. Secondly, still to the same, you find that the judiciary is under capture currently. The judiciary is not independent. And even when the few who have been bold enough come out and try to be independent and live up to their oath, you find that the same is demonstrated with caution, and it is evident in their writings that we are under capture, and whereas I am trying to be independent, I will probably answer to the Almighty and not to any other person. So such statements are the ones that drove our decision to have the executive order number 12 out, so that we try to, or we abolish some of the many conducts or actions that have been ongoing that give the judiciary superiority, and yet the actual power and the mandate on which they ride or enforce is one that is given unto them by the common man, the common Ugandan, of which even the advocates themselves, the members of the bar, are part of the wider membership of the Ugandans. I have been in Kenya and also had the privilege of associating with one of the senior judges or justices for that matter, and he did not have any trouble whatsoever with being called Mr. Justice or Mr. Judge. So this is one of the things that informed our decision, with the wisdom of the president's guidance, that if most of our neighbors who have moved away from the archaic titles, the archaic conduct and actions of, of elevating justices beyond the common man, have implemented it, then why is Uganda lagging behind in such an era of digitalization, in such an era when we must fight decolonization at all costs? Because the same titles only move in simulation and in conformity with the aspect of bowing, because they also still elevate a judicial officer above the ordinary Ugandan, and yet the mandate is gotten from the Ugandans, the people that they serve. So those are some of the aspects that really informed us, that moved the governing council to issue the executive order number 12 of 2026. Yes, you've said it has gotten wide circulation, wide publication, and as well as feedback. It is one that was timely, because for something to have moved beyond the confines of Uganda to other nations and had the kind of discussion and deliberation that executive order number 12 had, it means it is something that was timely. It is something that ought to have been made practical long ago, but we are just seeing it now. So that is something that informed the same. And we've seen that whereas maybe some members, the detractors and the regime apologists, find the same as being negative, the wider membership really finds the said message welcome, because many questions are asked about why would I be bowing before someone who is also under capture by another person? Why would I bow before someone who is not exercising their mandate the way they should exercise it under the Constitution? So those are some of the factors on which we best to have the said executive order come into force. Thank you. I believe I've ably elaborated on the same.
Yes, Mr. Babu, thank you so much. You have done more than expected. We were really wondering where this imagination came from, but you have showed us how meticulous and organized you are as the governing council, that it is a common and collected decision to make these executive orders so that any of you can speak to it. And that for us is supposed to mean that we have the foundation granted so that lawyers, as has been said in various social media platforms, are wondering how this executive order is going to be implemented, because it is really about the lawyers. Whereas we are all lawyers, the different lawyers from different walks of life will need to adjust accordingly. But, you know, it is about change, and the Radical New Bar Governing Council, under the guidance and leadership of Isaac K. Semaka, the Senior Council, came here to make a change, and an impactful one. If that is the case, then we need to support you. Thank you so much, Mr. Babu. You've been very eloquent to that extent, and we appreciate your insights, given that you've offered a better foundation regarding the EO12. Ladies and gentlemen, we're going to go forth and listen into the response of the Governing Council leader, Isaac K. Semaka, the Senior Council, to the President's State of Nation address, especially in regard to the issue tackling bail. And we're going to listen into a staff member who is online joining us and has been gracious enough to receive the instructions to read out that statement, which is going to get us into a transition to listen into members of the society and also members of the general public, but also usher into one of the guest speakers that we have online in order to help us unpack what that statement will have meant, but also what the president's remarks are supposed to mean for general consumption as a country. I would like to welcome Ms. Tusime Vanessa, who is online with us, and I would like to kindly ask her to unmute and read out unto us the statement as has been given to us. Ms. Tusime?
Yes, good morning.
Good morning to you, please. You're loud and clear. We would like to hear you out in regard to that statement. I thank you.
Okay, thank you so much. Thank you so much. My name is Ms. Tusime Vanessa, and I work with Uganda Law Society. And I will be reading in verbatim the speech of our most perpendicular president of the Uganda Law Society, Senior Counsel Isaac Semakade, in regards to the message that was delivered by the President of the Republic of Uganda. And it goes like this: Kampala, Uganda, 4th July 2026. The Uganda Law Society, ULS, strongly condemns President Museveni.
Vanessa, the heading, I'm sorry, it should be very specific.
Yes, the heading: the judiciary must unequivocally condemn presidential remarks on Besigye and bail. Kampala, yes, Kampala, Uganda, 4th July 2026. The Uganda Law Society, ULS, strongly condemns President Yoweri Kaguta Museveni's public comments today on the pending trial of Dr. Kizza Besigye and his stated intention to abolish bail. We call upon the Chief Justice, the judiciary, top management, and all judicial associations to unequivocally denounce the executive interference. President Museveni's address constitutes clear sub judice contempt of court by publicly speculating on Dr. Besigye's motives
conduct, and the merits of an ongoing case, he has prejudiced the accused's right to a fair trial. These remarks further aggravate existing contempt allegations involving the president's son, which are central to the human rights violations forming the basis of the current stay of proceedings. Beyond this matter, the president's renewed attack on bail is an constitutional assault on Articles 23 and Articles 28 3A of the 1995 Constitution, which guarantee personal liberty and presumption of innocence. Bail is a judicial function not subject to executive directive. A blanket policy abolishing bail violates the United Nations Standard Minimum Rules of Non-Custodial Measures, Torture Rules of 1990, and the African Commission's Rwanda Guidelines 2014, both of which mandate that pretrial detention be an exceptional measure of last resort. It also breaches the UN Basic Principles on the Independence of Judiciary, 1985, particularly Principles 1, 2, and 4, which prohibit governmental interference with judicial functions. The president's continued commentary on active trials and judicial processes undermines judicial independence and public confidence in the courts. Banning bail will not protect witnesses. It will instead punish innocent and shield synthetic failures from scrutiny. Our demands: 1, to President Museveni, immediately cease all public commentary on active court cases, including Dr. Besigye's trial, and refrain from directing judicial outcomes on bail. Such statements violate the sub judice rule and the Constitution. Then 2, to the judiciary, publicly condemn the interference without delay, consistent with the principled stand taken by Magistrate Sheila Gloria, a team in Uganda versus Miriam Matembe, Luzira Criminal Case 132 of 2026. Judicial officers have a duty under the UN Basic Principles to defend their independence. 3, to government, stop undermining fundamental rights, confront the real crisis in the administration of justice, that is, systematic judicial decay, political persecution, corruption, weak witness protection, and military/executive interference. The ULS remains resolved in defending the rule of law, constitutionalism, and the independence of the judiciary. Signed by Senior Counsel Isaac K. Semakade. Thank you so much for listening. May God bless you.
Thank you very much, Mr. Sime Vanessa, for those very, very unequivocal and eloquent statements that you have read out, authored by the most perpendicular, the way you described him as he is, Senior Counsel Isaac K. Semakade. And it's always it's impossible to avoid the president when you're in his environs. And being a staff member, I want to imagine Ms. Vanessa has developed very, very much under the guidance of Mr. Isaac K. Semakade. He is a person who always empowers people around him, and it is very important to take note of such senior lawyers who are interested in developing the young lawyers. So, Ms. Vanessa, thank you so much for the opportunity to read out the statement. And the statement is going to give us a platform upon which to rely, and also welcome our next speaker, who is also a member, a very senior member of the bar, and a friend and a leader in the Radical New Bar structures, and is very, very intent on matters human rights. He's a human rights advocate, and he is going to render unto us his remarks on this statement, but also give us a general perspective of the President Yoweri Kaguta Museveni's remarks in regard to, one, his State of Nation address, but specifically also tackling the matter of bail and Besigye, following that statement that has been read to us by Ms. Vanessa. Ladies and gentlemen, kindly welcome with me the Vice Chairperson of the Uganda Law Society Section 3C Committee that was recently launched, Mr. Stephen Kalali.
Well, thank you, Mr. Jurua, and the members online. I believe I'm audible now.
Yes, Mr. Stephen Kalali, you are loud and clear. Please proceed.
Yes, my name is Kalali Stephen, and the introduction, as you've said, I don't want to repeat it. It's self-speaking. I'll start with the comments on Senior Counsel's statement and projections that my sisters just read out. I would say, like, we know our judges in the appellate courts normally write down. I have nothing useful to add or subtract, but it's clearly evident that apparently the situation we are facing is all institutions are under state capture. This I've always said time and again, that we are having one institution that is functioning in this country, and that is President Museveni and his family. So that institution has managed to stiff all others, and they are functioning or doing whatever they are doing to favor him, to the extent that even the judiciary, which is the bastion of hope for us as lawyers and members of the public, they also cry for themselves. Judicial officers are afraid of making independent decisions because they are not certain about what will happen tomorrow. If the appointing authority comes out and boasts about making phone calls to judicial officers, goes on to make mockery of some of the litigants who are presumed innocent until they are proved to be guilty or they plead to be guilty, it's really something that is unusual, and clearly foretells the fact that we are no longer in usual times. Some of us were not there in the Amin era, but what we read and what the president himself has been saying about it, you could believe that certainly this regime is no longer giving us any good vibes better than those of Idi Amin, save for the sugar-coated stability. So I wish to also project my voice in that regard, that the statement as made by ISK Senior Counsel is clearly viable and formidable, and my submission or meat that I would do top for that is, I wish all members of the bench, even at the higher rankings, stood firm like our sister Gloria Atimu and respected their oath. We all know that much as most of them now look at the Constitution as a useless paper, this Constitution is the cornerstone and the bottom line or foundation of all rights we are having. So if the members of the judiciary accept to be stepped on and now be used as tiptoes for torture, the sky will be the limit. So in that regard, I really appreciate the president and always pray that wherever he is, the Lord keeps him safe and his family, and let him keep standing firm for rule of law, especially coming out to comment on some of these illegal and unconstitutional practices that are ongoing in the country, which are also covered up or condoned by the institutions of justice. As regards the topic that we have today, I think it clearly entails the limb of political leadership, especially the president of Uganda, trying to influence or impact on court decisions to grant or deny bail in capital offenses. And this does not only go about denial of bail, but also sometimes it stretches to influencing decisions. Because we have seen it time and again also the first son tweeting, like for example, Mr. Muhoozi Kainerugaba saying the accused persons will be hanged anytime soon. So that is something that goes on with executive interference or influence in the bail-making decisions and the justice system. Our colleagues online and members of the public, if any, we need to, first of all, unpack and understand the essence of bail. Bail is a constitutional guarantee, or literally speaking, it's an arrangement or an agreement between the litigant and the state or court warranting that that person will partake trial fully without missing. And this stems from the right to liberty. The right to liberty is provided for under Article 23. We are all aware of that. And then this stretches to the limit that we ought not to be deprived of our right to liberty arbitrarily, or in case we are detained, and the presumption of innocence is stretching in under Article 28. Let us be tried within the shortest period of time. This I don't mean 1 day or 2 days, the Okero Onyom way. We are looking at a fair hearing that entails giving someone sufficient time to prepare for their defense, to the state to prepare for its prosecution, and also the court itself to appreciate the case it is trying before the members of the public and the litigants at hand. So here in Uganda, apparently, what we are facing, or the limb of the influence, is the president comes out and gives his State of the Nation address, which is purely focusing on people or accused persons being adjudicated, in his opinion, as guilty until they prove themselves innocent. Because he is telling you, when Mr. Kalali Stephen is arrested and charged, why should he be granted bail? Now, the Constitution is very clear. It is saying we have a right to apply for bail. It is not saying I have a right to get bail. It is saying I have a right to apply for bail, and then the court, instead of taking into account, one, my right to liberty. And this, I will tell you in my submissions, that looking at all the international instruments, that is the African Charter on Human and People's Rights, the International Covenant on Civil and Political Rights, the articles therein stretching from Article 6, that is for the African Charter on Human and People's Rights, Article 9 of the Universal Declaration of Human Rights, and then Article 9.3 on the International Covenant on Civil and Political Rights. All these, they focus on the fact that as a general rule, keeping a person in custody permanently before trial shouldn't be the key parameter pertaining any matter before courts of law in the criminal area of justice. And why? They are looking at the fact that Mr. Kalali Stephen, as is being tried, or Dr. Kiza Besigye, these people have families. You see, Mr. Jurua and colleagues online, what our members of the bench have failed to appreciate is that whereas Mr. Kalali Stephen may have rights that are, or Besigye may have rights that are restricted under Article 43, there are other dependent rights that are coming along with mine. For instance, Mr. Besigye has a family. Now, when you have a family, the family members, if you're the sole breadwinner, they are purely dependent on you. Now, what do these family members have? They have a right to health. If it's children, they have a right to be with their parents. Now, if you're balancing the rights and looking at the fact of a fair hearing, you ought to consider this. If someone is no longer at home, the wife may not be working, the children were school going, and these exceptional circumstances that warrant granting Mr. Besigye or Ivan or whatever a temporary relief in regard to bail, as opposed to listening to what the president is saying. Because you see, the president is not an investigator. He is just given a brief. He may not even understand what the case is about. So we have a challenge of politics and law. And I will tell you that politics and law, they can never be in the same bed. So for him, he gives his opinions politically. They are not evidential-based or legally grounded. The same president wrote the 1995 Constitution. And the Constitution clearly says even him, he is our servant and he ought to respect our rights. He is supposed to account to us. So his power is derived from us, whereas we understand he illegally took over power through militarization. When he brought the Constitution into play, it means he's supposed to oblige to the provisions therein. So if you give political opinions that are intimidating judicial officers, that are intimidating litigants and influencing decisions, it means we are going to the days of the Idi Amin era and worse. Because nothing pains like someone giving you a piece of paper, pretending that I'm saving you, yet in actual sense, they are killing you. Mr. Jurua, as I submitted earlier, the topic of the line of my discussion on the right to liberty and bail, as well as political influence, as I cited Article 6 of the African Charter on Human Rights. That article clearly talks about the right to liberty and security of person. And security of person, when you look at it, that's what we consider when you're looking at bail, issues to do with bond, among others, that the personnel before you is likely to appear and also partake throughout the conclusion. And then one other clear aspect I would talk about why the right to bail or someone getting bail is necessary is preparation for your defense. Jurua and colleagues tuned in, you all agree with me, or if you have never known, the reality is when it is rare for an accused person who has been arrested and they make statements to be allowed at that moment to adduce witnesses who make statements on their behalf at police. They are not accorded that opportunity. The state, what it does, it just gets the suspect, you make a statement, and that is all. Now, when you're in Luzira, you're facing a capital offense, or whatever prison we may talk about, how will I be in a position to secure the attendance or even obtain the evidence of my people who are the key witnesses I have? And this is where now the right to grant someone bail becomes necessary as being tandem with fair hearing, because as I'm preparing my defense, I need to also prepare my witnesses. Now, if someone is in New Zealand remand for 5, 3 years, 4, even the witnesses I saw that ought to have given my side of the story cannot be located. So when you ask me at the moment of trial that produced them, it's just a mockery, because how would I even trace them? Some of the gadgets have been confiscated, like phones, among others. These people always change contacts. We saw this vividly. You saw at Onyom's hearing, Okelo. The contacts they were calling, some of them were off. So if someone is facing charges that certainly, unfortunately in Uganda, like capital offenses are always, the trials don't kickstart immediately. You wait for sessions, except for Dr. Kiza. So if you're focusing security of person, if you're focusing on security of person and the right to liberty, I believe bail would be a key aspect. And this is not strange in our jurisdiction. We have decisions in Uganda, like Tumushabe versus Attorney General. I think it's a constitutional petition of 2005. Should be petition number 4 of 2005. It discussed the fact that the right to liberty and one being given bail is fundamental and universally guaranteed. And that very decision goes along with another decision of Dr. Kiza Besigye versus Uganda. It is so mind-touching that actually Dr. was contributed greatly to the jurisprudence of this country in terms of the criminal justice. Some of the decisions that clearly he has on record, they have not been in a position to help him. They are now being abused by the institution of the judiciary. The case I'm talking about that it goes along with is the Kiza Besigye decision versus Uganda, criminal application 228 of 2005. In that case, his lordship of as he then was, he emphasized on the court's obligation to jealously, I mark the word jealously and courageously protect the rights of all individuals. When you're handling a criminal matter as a state attorney, as a magistrate, you're handling rights of an accused person who is presumed innocent until proven guilty, and also the rights of the state. But in the circumstances I've explained, someone has people who are dependent on him, there are people whose rights survive on him. Why wouldn't you courageously stand up and protect their rights? And this, in my view, like the president discussed, I think is also attributed to the problem of our judiciary or some of the judicial officers forgetting about the judicial oath. Colleagues, it all starts with, if we are looking at the judiciary, Article 149. You take oath as a judicial officer to administer justice without fear or favor. And from there, you are moved to Article 126.1, that judicial power shall be exercised in accordance with the people's norms and aspirations. And that along moves also with Article 128 on the independence of the judiciary. These are constitutional provisions and mandates on the judiciary, and also to the president with his executive. You move to Article 20, that we have fundamental human rights, Article 20, Clause 1. These rights are inherent and not granted by the state. So that means in all we are doing, whether I'm facing criminal charges or everything, my rights, presumption of innocence, the right to liberty, among others, at the back of the judicial officer or whoever is handling my matter, they ought to know that my rights ought to be respected and they are not granted by that individual. Apparently, what we are seeing is like the head of the state and his son, they are clearly telling us, look here, Jurua, I am the one who determines what right you have, when you should enjoy it, and to what extent, which is clearly unconstitutional, and it clearly shows an overhaul or overthrow of our constitution. Mark you as I submitted, Article 20, Clause 2 is giving them an obligation as government and all organs, which include other institutions, judiciary, among others, to uphold and protect the fundamental human rights. Jirua and colleagues, concerning the independence of the judiciary and how the executive is going ahead to determine, I submitted on Article 128, and I just don't want colleagues to forget, we also have the Bangalore Principles of Judicial Conduct. And therein, principle number 1 also emphasizes on independence of the judicial officers. These officers, once they are appointed, they no longer belong to the appointing authority. And I believe that's where we have the problem. Our judicial officers fail to understand that once you're appointed, you're no longer belonging to the appointing authority. You're supposed to uphold the constitution and serve Ugandans or citizens. Because it is us who brought the president in power, it is us who man these institutions through the mandate and the trust we give the appointing authority. Now, if for you, you're looking at promotions, because that's one of the problems we are having. Whereas we say the president influences, no. The two problems we have in Uganda towards the institution that we are discussing now are, one, looking at promotions. Someone wants to run through so fast and they become a deputy chief justice, they want to become a judge, they want to become a registrar, so they have to do all wrongs that are needed in a bid to achieve that goal. 2, cowardice. We have a problem of judicial cowardice. And judicial cowardice is what is eating up most of these institutions. People are forgetting about their judicial oath and faith, as well as the fact that whereas you're enjoying that bench, you will one day get to the public and you will be judged. So are we willing to have self-empathy of, am I making a decision I can stand with in the public if tomorrow I left the bench? That is a test that most of these brothers of ours have failed to meet. And I'm saying, if we can have a remedy for those two, because there are people within the bench, I can tell you, they are justices, we have magistrates who are at the bench and they are willing to do the right thing, but they are suffering the cat syndrome, or the burning bush and monk syndrome. I'm always saying that. And that is where a young monkey sees the forest burning and it is celebrating. Or a cat is busy eating pregnant rats, forgetting tomorrow it will want to feed. And this is in sort of isolation. They fear. Someone says, I'm willing to write the right thing, but I fear to be isolated. How will the others look at me? He says, I will give the right, but now I'm isolated. We are few. The majority are looking at making incompetent decisions, injudicious decisions. But for how long shall the judiciary as an overhaul accept to be used as tiptoes of torture and political persecution? I'm handling Dr. Matembe's matter. Like I told you, and I would like to say it here, we failed even to get any single name of the complainants. There is no Munyankole woman on record who made any statement saying doctor, whatever she said was promoting sectarianism. No. This is just a situation of where someone determines what institutions should do. And they draft whatever they want, they put in court that rubbish, and someone is taken to Luzira. Because they say we shall determine who should be out and who should be in. And you saw the president come out in his speech commenting all that about Dr. Kizza Besigye and the rest. The same way you've seen the two decisions, in my view, with respect to the judiciary, that I believe they are not grounded in law. In the Kizza Besigye bail application, to someone who has studied the constitutional law and understand the right to fair hearing, which was ably put under Article 28, and it entails the right to effective legal representation, as well as discussed in the case of Honorable Bakaluba versus Betty Nambozi. It is an election appeal. It is an election appeal. It is an election appeal number, should be number 4 of 2009. They clearly discussed what a fair hearing entails: adequate preparation, right to legal representation, the right to counter the evidence by one side, and the right to submit on my side. So if someone tells you, I had my 2 lawyers, and these lawyers are now incarcerated, for you're saying they are just wasting court's time. As of such, you're dismissing their application for want of prosecution. Who does that? Who does that? Looking at the constitutional obligation you have as a judicial officer under Article 28, it can't be possible. It can't be possible. So in my view, I believe, whereas we consider and talk about executive influence, which is clearly not so much debatable, because we see how overhaul it has been brought out, but also the initiative, the individual judicial officers' willingness to stand by their oath and deliver what is expected of them is the biggest challenge. You see, also what we need to understand is under Article 10 of the International Covenant on Civil and Political Rights, it provides for all persons detained to be treated with humanity and respect of their dignity as a human person. And of course, all these, as I was submitting earlier, they all get to be tandem with the obvious articles I talked about of Article 23. We have clause 6 there on applying for bail, the presumptions of innocence, among others. And also the fact that what I would still attack, I can't live without tackling it or attacking it, is I believe our bench members also forget, or they have not addressed themselves to the UN basic principles on the role of lawyers. When you look at the UN basic principles on the role of lawyers, particularly principles 16, 17, and 18, they lay down what the government, which includes, of course, the judiciary, is expected to do in facilitating us as lawyers to partake our role. And 18 clearly addresses the senior counsel Lukwago's issue, that as an advocate, we shall not be persecuted or aligned in the line of our duty while executing our work with the clients. You're being persecuted because of what you're doing. Inherent powers to fight such abuse. Because this is clear abuse of court process. Today it's Council Elias Lukwago. Tomorrow you will be the one. Because each one of us, when you're having interaction with a client before you take on instructions, they either give you the truth or the falsehoods. So by virtue of my interaction with the client, tomorrow it will become a habit. State attorneys will be charging us. And that is one way to stifle or to stampede on the right to fair hearing. Merely because we should ensure that we frustrate Dr. Kiza Besige and his legal team from partaking the effective representation, so that maybe we can have our own lawyers we give him. Now, if we need you as the state, you're saying you have the evidence, why are you turning the guns to the lawyers? I thought an effective judicial system would also ensure that if Stephen Ovesije is being tried, let his lawyers all be at the forefront and the game gets to be played. I mean, it's 90 minutes. Let us pray. If it goes through, we go to extra time. But you, as the bench, you are favoring one player who has got Council Juruo handcuffed him and is saying, okay, Juruo, I want you to play number 7 with those handcuffs. And you should be able to cross all the balls to the striker who is number 9. It can't be possible. That means we have a constitutional overhaul. Completely. So all the institutions we have, they are bending to one personnel. Before I part on all this, having discussed the political influence, so I will refer to the famous quote of one of the scholars, that is Socrates, 2,400 years ago. That gentleman ably described the essential qualities of a good judge as follows. Said, the qualities of a good judge are 1, to hear courteously. 2, to answer wisely. 3, to consider soberly. And 4, to decide impartially. All those, I underline them for emphasis. Now, in the context of the Ugandan bench, and how some of the criminal trials we are seeing are ongoing, the denial of bail, among others, are we seeing 1, judicial officers who are hearing courteously? A litigant is in court, is addressing you as a judge, you stand up and walk out. Is that being courteous? 2, answer wisely. And answering wisely doesn't mean only to talk to me. It means you can answer me even through your racial disdander in a decision. Now, if you as a judicial officer, you issue the directives and say the state should avail all the necessary documents to Dr. Besige's team, and they should have access to him in prison at whatever moment it's needed. But it so happens, these orders have never been respected. Now, you as a judge, a litigant tells you that ABCD has not been adhered to, but you are saying, no, you have wasted my time. We are proceeding with the trial on 13th July. Is that answering wisely? Is that considering soberly and deciding with impartiality? Those are questions for us to answer, look into, and decide on our own. As all said, my submission is, Uganda is at a stage where we still need more judicial activism. And I will use partly the words of Justice Batema in Busobozi versus Uganda and another, where he referred to the case of Parker versus Parker and the quotes of Lord Denning. That merely because it has not been done before doesn't mean we should keep our hands tied and we look on. Our members of the bench, we believe you have the competence, some of you have the heads, you have the capacity to give the public what it wants and to restore the public trust. You cannot stop the president from commenting whatever he may want to say in his political statements, but stand by your oath. The fact that apparently nothing has been done before to stand firm and grant Dr. Kizza Besigye and the rest bail cannot stop you from cleansing your heart and you say, let us have this person temporarily. Because I mean, the state has all the mechanisms. Even if it means getting, how many times has Dr. Kizza Besigye been granted bail and he cannot run away? Council Lukwago is pleading. The doctors at Mulaga have written to you a report. They are telling you this gentleman needs serious medical attention. As a judicial officer, you have the audacity, for God's sake, someone who took oath to adjourn that gentleman's matter to 16th. I mean, you asked for a medical report. These are experts who have given it to you. What else are you looking out for? Do you want a dead body? And then afterwards, in the public, you will be moving with all the confidence that, yes, I'm a judicial officer. I think maybe in my understanding, I don't understand what the word justice means. In my opinion, if you're doing such a thing, you are an agent of injustice. You're not an agent of justice. It is high time we separated politics, political statements from judicial exercise of power. You as judicial officers, they understand the power they have by a mere stroke of a pen. Now, if we use that power injudiciously, then borrowing a riff from Panj versus Republic, the sky will be the limit. So, Mr. Jiruo and members or colleagues online, my submission on that topic is that way. In regard to political influence and then judicial discretion as regards to bail. I've talked about the right to liberty, the presumption of innocence, among others. That's my parting point. Members of the bench, and not only the bench, much as today we have discussed the bench. I'm talking, I address all institutions, the office of DPP, Attorney General. You are accountable to the public. That's why we have Article 20, Clause 2, that you should uphold, respect all individual human rights. So if you are serving one person because you want to be promoted anywhere, the people you're supposed to uphold these rights for include your family and relatives. That injustice you're serving, one day it will knock on your door. And that's when you will understand that indeed justice ought to be given to others. Those are my parting shots, that let us not allow to be used as tiptoes for torture and political persecution. We shall still stand firm to defend the rule of law. And those at the bench, those in all institutions who are willing to stand and fight for rule of law, let us not give up. We believe there is hope, and we shall continue to stand for the right things.
Wow. Thank you so much, Senior Advocate Stephen Kalali, who, as I described before, is a very ardent member of the Uganda Law Society Section 3C committee and was not just appointed for no reason. If you can follow what he has said and how he has ably unpacked the president's statements in regard to Dr. Besigye and bail. Of course, Dr. Besigye and Obed Lutale, we don't forget him, and bail, but also in regard to the statement that was read out by Ms. Tusime Vanessa, authored by the President ISK Senior Counsel in regard to the same topic. And you have done the discussion justice without even asking for anything more. You have spoken from your heart. We've gotten comments of how radical you are, but indeed you belong to the Radical New Bar and you are a brain behind it, among other people who we don't necessarily have to mention because you are seen by your actions, Mr. Kalali. You have done us a lot of service. You have taken us through the history of bail. You've given us the constitutional guarantees about bail. You have also quoted very many cases that we are going to use to learn, because this is a learning platform. We are never all knowing. When we host very, very diligent people and lawyers like you, for us, it is about time to take the pen and paper to start writing these notes. I have been a big beneficiary of your lecture per se, which is in form of remarks, but you have done so much justice to read. I've also mastered a few international instruments that you have quoted and cited, which we are going to read out to the members because you were reading from your heart, and yet we should know by now as young lawyers and all the other members of the public, but also as lawyers, regardless of your seniority, because we don't know everything. And this platform presents to us an opportunity to learn and unlearn whatever we thought we knew. You have ably spoken to the statement that the president read out, and you gave him a lot of gratitude because you said it was a very formidable and welcome statement, which everybody else, of course, appreciates because it has gone global and it has put judicial officers who are either gullible or petty or who have forgotten their oath and have failed to stand up to the occasion in their place. If you cannot exercise integrity, then you don't deserve to be called your worship, neither should you be called your my lord. If you are going to walk out of a court session when an accused is making his case, like you have stated in the case of Dr. Besigye at the High Court, Judge Baguma, I think that is how the president has asked us to speak about them, to just walk out of court. Are you necessarily being courteous, as you have cited the Socrates qualities of a good judge, to hear courteously, to answer wisely, to consider soberly, and very importantly, to decide impartially? Thank you once again. You have easily stated how all the members of the bench, like Gloria Atim, Magistrate Gloria Atim, should stand up and be counted, because eventually it is the public that will judge you. If you don't want to be judged by the oath that you took, the public will be out there to judge you. And I remember in that matter, which you have also identified, of Honorable Matembe, in which you have been a very big part and done so much to ensure she got bail, for which we thank you as the bar, of course, and as a senior brother to us from whom we are learning. We thank you, and you ably showed us how the first time that she denied bail after Honorable Matembe was easily seen on the video, very emotional. A mother of ours, very emotional, asking the magistrate to listen into her heart and consider Mama going home to, get medical attention. She spoke of her back. She spoke of so many ailments, as we've all had, and she has been awash social media, and she denied bail, and eventually her picture was awash social media, and members of the public took to, speak about her, and, it had an impact on her, because eventually when Mr. Kalali and company went back to apply for bail, having had that adjournment, she bowed down to the public cry and outcry, and she was able to give bail. And, you know, she was given the flowers that she deserved, because, I mean, this is a public figure, just like Dr. Besigye. Many times that you've spoken about, he has been given bail, and he has, you know, actually been on house arrest where it has been necessary, and he has obliged. And the fact that bail is really just to ensure that you attend your court sessions is exactly what bail is meant to be, to guarantee that aspect of freedom of liberty. And being that the Constitution is the cornerstone of all the rights, it is a blessing that you can have able-minded members of the bar like you and the president, ISK, Isaac K. Semakade, Senior Counsel, speak out on these things that are happening that could not be done either before or have been looked at with half an eye. And the limbo of political leadership and influence, Mr. Kalali, that you've spoken about, brings to the fore how much there has been laxity in implementing and standing by oath by the judicial officers, just because the political arm of the government has made one or two statements, which of course is a very big a shame. We want to come to the fore and be seen to be speaking. If Muhoozi can easily say that those members are not going to get bail or they're going to be hanged, Mr. Kalali, you've mentioned that, and it defeats the essence of bail, where members of the public are either adjudged to be guilty rather than innocent before being proved guilty, and therefore a warrant of bail is supposed to be the case. And you have been able to guide us and lead us to the different international principles, or rather international instruments, that I would like to easily bring forth to the members, so that it is not in vain that we are either learning or trying to look into what you're teaching us. You've spoken about the Bangalore principles of judicial conduct, which of course speak into how a judge or a judicial officer is supposed to take him or herself. And of course, the principle number one reads, if you don't mind, it's actually the value number one is about independence, and the principle reads judicial independence. If you have the time, you can kindly download these principles, because they are online, and of course you don't get such lectures very easily, and they're not taught in class. For those that are lawyers, you will know that some of these things are not taught in class, but also for the public, for your intervention, for your knowledge. It's very important for you to know these things, so that you're able to face off with state actors or maybe duty bearers who are covered by the name of the state. You should be knowing your rights in order for you to be listened to. The principle reads, judicial independence is a prerequisite of the rule of law and a fundamental guarantee of a fair trial. A judge shall therefore uphold and exemplify judicial independence in both its individual and institutional aspects. The principle goes ahead and gives us application. And Mr. Kalali, if you'll allow me to read, I'll continue and say, it's in 1.1, it says, a judge shall exercise the judicial function independently on the basis of the judge's assessment of the facts and in accordance with a conscious understanding of the law, free of any extraneous influences, inducements, pressures, threats of interference, direct or indirect, from any quarter or for any reason. Yes, these are quite critical principles that you're not going to get in class. And if we're going to get them from our senior brother or senior lawyers like we have here, then you need to know that we are set for the right future, and we're in the right trajectory of how we want the rule of law to be exercised. 1.2, Mr. Kalali, if you may allow me once again, and members on call, a judge shall be independent in relation to society in general and in relation to the particular parties to a dispute that the judge has to adjudicate. This, of course, can be looked back at from the scenarios that Mr. Kalali has identified in the different cases he has quoted, including, among others, the Dr. Besigye versus Uganda Criminal Appeal 228 of 2005. He also was able to cite for us a case, Tumushabe and versus Attorney General Constitutional Petition number 4 of 2025, in which it was declared that the rights, these rights are very fundamental and they are guarantees that cannot be easily wished away. So we need to be cognizant of these principles, but also he continued to encourage us as lawyers that while we are practicing, we need to be knowledgeable that there are very many international instruments that cover us, protect us, that we have to get to know in order to be confident in your practice. And of course, Mr. Kalali, you're my witness that the president of the Uganda Law Society, Isaac K. Semaka, the senior counsel, has forever been teaching us about these things, because we are either ignorant, or we have refused to listen, or we have refused to do some basic research, which gives us the confidence within which to operate and know how to stand to the judicial officers without necessarily fearing anything coming to us. And you've cited the basic principles on the role of lawyers, for which we have one of them. Of course, these are documents that I would like for you to all download and see to it that you read after this. Access to lawyers and legal services. This is principle number 1, but I think you cited 18, you cited 17, 18, and 16. The first one, of course, is really just access to lawyers. All persons are entitled to call upon the assistance of a lawyer of their choice to protect and establish their rights and to defend them in all stages of criminal proceedings. And that, of course, is supposed to be speaking into the fact that we need a fair, adequate representation by counsel. You cannot, in this scenario, of course, of Dr. Kizza Besigye, his lawyers have already now been put either behind bars or declared persona non grata, and that is, of course, a scenario that we also addressed at some time, or under the leadership of Isaac K. Semaka, the senior counsel. Martha Karua, senior counsel, was deported, and yet she is a lawyer for Dr. Kizza Besigye. And not long after that, we saw that Honorable Arias Lukwago was also taken in and put behind bars, and very, very, very shamelessly. Yet he is also a lawyer for Dr. Kizza Besigye. So you find the access to lawyers, in as far as the UN basic principles on the role of lawyers is being stifled. But Mr. Kalali was able to quote for us Section 16, which reads guarantees for the functioning of lawyers. That is the heading: governments shall ensure that lawyers, A, are able to perform all of their professional functions without intimidation, hindrance, harassment, or improper interference. B, are able to travel and to consult with their consultants freely, both within their own country and abroad. You can imagine the scenario that has just been quoted about Martha Karua, senior counsel. It's very, very, very disturbing. And finally, C, shall not suffer or be threatened with prosecution or administrative, economic, or other sanctions for any action taken in accordance with recognized professional duties, standards, and ethics. Ladies and gentlemen, this is for your consumption. I know it could be breathtaking. It could also be a lot of information for you now on this call, but this is for you, like I said, is for purposes of studying, appreciating, and getting to know who you are as a lawyer and what role you have in as far as ensuring rule of law and access to justice is concerned. Principle number 17, Mr. Kalali and the members on call, reads: where the security of lawyers is threatened as a result of discharging their functions, they shall be adequately safeguarded by the authorities. Imagine, Honorable Lukwago, I was privileged to be in court that day, very recently, I think on Monday, when it was Tuesday, sorry, when he was being arraigned. Maybe for the public to know, there was no information that it is going to be a Zoom call hearing. It was up for mention, and when the lead counsel, that was Honorable Segona Medad, went into court with a few other lawyers, including Mr. Tumushabe and Mr. Muyizi, were in court. It was surprised to see that it was going to be a Zoom call, and the judicial officer, Mr. Kalali, as you said, even refused had turned down the opportunity to listen to the inmate, the accused, Honorable Lukwago, and yet his hand was up. He intimated to the courts that he needed to speak to the court, and the lady, the magistrate, chose to attach herself to jurisdiction, saying that she doesn't have the jurisdiction to listen to the matter, and she was simply instructed to adjourn. But the lead counsel said, I mean, fine, you could be having instructions to adjourn, but listening to the inmate, a very critical party in the matter, should not be a matter that requires you to seek jurisdiction. And ladies and gentlemen, members on the call, Mr. Kalali, the intimation and the cry out of Honorable Lukwago was very deep. He was specifying the details of the medical checkups and the documents that he was given, because he was at Mulago Referral Hospital for over a week, and he spoke so deeply about the challenges that he's been facing, and just having him come out on bail to go for medical attention, you can see he's very frail, he's very broken. He is ready to stand trial if it is necessary that he stands trial, but the basic principle of bail requires that you be released on that condition that you come back and go back and be attended to. So yes, the points that you're raising are very, very important for us to sit back and reflect as lawyers. The basic principles on the role of lawyers are very, very important for us to continue to listen out and to. Mr. Kalali also cited the International Covenant on Civil and Political Rights, which of course is supposed to be one of those very critical international instruments that help us to understand how much we need to be addressed in as far as the courts of law are concerned. And Article 1 says all people have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. So we're trying to, Mr. Kalali has been trying to separate politics and judicial exercise of independence, having quoted the different articles, of course, in the Constitution, including Article 128, which deals with the independence, yes, of the judiciary. Then, of course, the Bill of Rights in Chapter 4, variously, including Article 23, that guarantees us that liberty and the importance of always considering that we cannot easily whisk them away because we have had political statements from the leaders of the executive, particularly, of course, General Museveni and the first son, the CDF, on the statements that he has been making, which, of course, leave so much to be desired, because it has led into judicial cowardice, where magistrates and judges are scared of being isolated, as Mr. Kalali stated, being isolated and asking what will others think and say if the others are not towing the lane that I'm towing, and yet your lane is supposed to be easily reasonable, integral, and mature and sane. So being tiptoes of torture and you know, wondering what will be said after this court session, he easily identified the fact that in the Honorable Miriam Matembe case, there are no complainants. We've had such scenarios where the complainant is not able to come forth, and that, of course, puts the DPP in a very, very bad position, and yet the DPP are holding members of the bar. They are not actually members of the bench, which presents a very queer position in which we wonder whether these colleagues of ours are serving the state or necessarily serving the members of the public. He also has helped us to understand and maybe give us more room to go and do research about the two decisions which are not grounded in law. Those decisions, of course, based on the Honorable Lukwago ruling on denial of bail, but also the one that is incessant in the public of Dr. Kizza Besigye. And that, of course, asks us to make sure we get some time and do that research, because it's all about fair hearing. Fair hearing, you can take home the fact that fair hearing is that a lot of the rights that are guaranteed in the Constitution don't operate individually, as we were learning under the leadership and classes of Professor Oloko Nyango some time back. In constitutional history, Mr. Kalali, you will know that the Constitution, he always preached that the Constitution should be read as a whole. You cannot isolate Article 23 from 43, and yet there are various other laws. As a breadwinner, just like Dr. Kizza Besigye is, the right to health is denied to the children or to the members of the household. The right to food, for example, if a person is a breadwinner. So we have a lot of work to pick from this discussion. Mr. Kalali, you've been very gracious to us, and we're so grateful. You've cited the case of Honorable Bakaluka versus Namboze election appeal number 4 of 2009. These matters are going to be on record, so you can easily visit this platform and recoup and recover these citations for you to read and maybe get a better understanding of what a fair hearing entails, because it connotes adequate representation, among others, listening to the other lawyer and considering submissions and so many other things that I implore everybody on this call to try to go back and get time to read. I need to make a specific interruption. That article that was cited by Mr. Kalali in the ICCPR was Article 10. I would want to run to Article 10 before we could open the floor to the other members of the public and members who are on the call to share their insights. I know there's 1 or 2 questions that we are receiving from the different members of the public to Mr. Kalali, but we are also going to be gracious enough to listen into people, because they are members of the public that have asked to also speak. Article 10, Mr. Kalali, that you quoted for us, reads, all persons deprived of their liberty shall be treated with humanity and with respect for the inherent dignity of a human person. Thank you very much. That is a very important line that we cannot leave without interrogating, but you've done justice to all these international instruments, and you are a very, very lucky man to know all these things, but you're even a better person to easily disseminate this information and create this kind of awareness for the public and the members of the bar. Article 10, subarticle 2A, reads, accused persons shall, in exceptional circumstances, be segregated from convicted persons and shall be subject to separate treatment appropriate to their status as convicted persons. But that is generally what we are discussing about. So ladies and gentlemen, get some time, get to reading, so that we are able to be on the same page with these senior lawyers, and as they prepare for us the way as we are growing and developing and trying to change the face of judicial practice, we shall continue to listen into such very educative sessions. I thank you, Mr. Kalali. You have helped us understand so many things, and you walked away by giving us so many things. The one of Socrates' qualities of a good judge is one thing that I think members need to take home, just to say them as you read them out to us. 1, to hear courteously, number 1. Number 2, to answer wisely. Number 3, to consider soberly. And number 4, to decide impartially. And then you asked questions as to whether we are seeing judicial officers execute these tenets? And of course, the answer is a big no, but also depending on the circumstances. But particularly as we're discussing today, we're seeing a big no to that question, and that leaves us with a lot of things to do. Mr. Kalali finally left with his parting shots, but requested, or rather advised, that members of the bench should stand tall and be counted to be executing their oath that they took, because judiciary and the judiciary needs judicial activism. A very important word and a very important statement that should help derive the need to participate in these dialogues and conversations so that we are all brought to the same page in as far as judicial activism and exercise of powers by the judicial officers is concerned. He didn't forget to lump the DPP and the Attorney General, who are accountable to the public regardless of their status, and a way in which they are representing the government doesn't make them any different from the lawyers that are members of the bar. So a cry and shout out to, a shout out to Mr. Kalali, but also a very stern message to the members of the DPP and the Attorney General, but also the executive at large, because it is looking like we are at war, and yet we should be sisters, friends, in the anticipation of how to ensure the Constitution is practiced and guarded jealously from the statements and ruling of Principal Judge Emeritus Ogola. Thank you so much, Mr. Kalali. We have a few questions to ponder about, but I want to first and foremost, the questions should keep coming. We're going to read them out when we've had from our members of the public. I have seen a few members here. Yes. Yeah, you are welcome, members, to give your insights about this topic. Kindly feel free, those that are available, and then we can easily engage the different speakers that will be speaking. But we want to enjoy this moment by learning. It's not anything wrong to learn, so that we're able to speak into the topic that has been discussed. Mr. Kalali, we have a question as we prepare. The public is kindly asked to raise a hand if you can. We can activate your microphone so that you can give us insights on what you have to say or think about these statements, or maybe react to Mr. Kalali's presentation, but also the statement read out by acting Secretary General, Mr. Babu Sali, and then the one that was read out on behalf of the President by Ms. Vanessa Tusime. So there's a question here, Mr. Kalali, from one Annabelle. Annabelle is asking, Mr. Kalali, you're very radical. What practical solutions do you propose for lawyers who are intimidated if they are going to be arrested for representing clients? What practical solutions do you have for lawyers who are intimidated in fear of being arrested? Mr. Kalali, are you still with us? I can see you're still on call. We would be glad to see you answer this question. Of course, you've given us the general perspective, but these are very specific questions. I would like to kindly ask you to join the call once again. Thank you.
Thank you, Mr. Jurua, and thanks to our colleague who has asked that question. I think first and foremost, one, the practical solution is we ourselves as advocates united. Unity amongst us is the best solution to all these problems. And two, us putting cowardice, I will still insist on that, cowardice out of the way. When you studied law, you took on the mantle to represent your clients in all ways and aspects vis-a-vis the conditions of work. And this is what we also see with other people who are serving in the respective entities. I would say if we unite as a society, and that's the essence why the president and the council deemed it necessary to establish Section 3C committee, I would still, not burdening, but I would request Council Juru at some point to read it for the members to understand. But precisely or briefly, that section looks at the Ugandan society having an obligation to protect the manner of environment under which our colleagues practice or perform their profession work there under. So that's why we have this committee. So if a colleague is kind of facing challenges in execution of their work, like what we are seeing with Dr. Lukwa, with the Council Elias Lukwago, whatever, we would call upon you to communicate to us as your colleagues, because we are leaders and we are here to stay unless God decides otherwise. So each time you're communicating to us about any challenge, we can always have the two options. One, looking at engagement with the respective entities. And the two, like you say that we have the radicalism in us, we can look at the radical bit of it in regard to the effect you have faced as an advocate in the line of duty. It could be torture, you were tortured. So why would I sit back as Kalali Stephen and look on when my colleague has been tortured? It's not about identifying the individual who tortured them, or if not, as long as those individuals were security personnel, I take on the Attorney General and we see that there is justice brought to book in regard to our colleagues who are in the profession. Otherwise, if we sit back, because I cannot advise you that because there is ABCD run away, that would be me again facilitating cowardice, or telling you that you go to the village and start harvesting whatever you are harvesting, leave the profession alone. So those are the two solutions, the practical ones. Each and every incident that is happening, like I know before area council Lukwago's issue happened, there is a colleague, I don't want to mention her name, let me withhold them. She was also persecuted, imagine, by a fellow colleague, a fellow advocate. The colleague goes and opened up a criminal charge against a fellow lawyer because they were having a land dispute that side of Luel, and this lawyer had refused to agree the terms of another colleague. So they arrest her in the evening hours. The lawyer connived with the state and they sanctioned the file. When she communicated to the president, ISK, he communicated to me and I was able to engage the respective police officers and then also the other council who seemed to be arrogant, I would use that word, but we managed to get to the bottom line of the solution and our colleague got her freedom back. So this is one of the practical solutions that we are talking about. Once you're faced with a challenge, communicate to us. We can assess and see how best we can go about it. There is dialogue, which we don't say that they will dictate terms for us, and two, the line of what was the effect of the problems you got on the duty. Are we taking an action to recover, or what best can we take on? So I believe, in my view, those two answers I've given can address that. If there is any shallow limb in what I've given, you can always ask and I add on something.
Thank you very much, Mr. Kalali. You've been very unequivocal in your call for cowardice to go out of the members' hearts, but also unity among lawyers. And that clarion call that you've made to the members to reach out to the Ugandan Law Society is equally important, because we are ready to support. We have a message here from Mr. Peter Angubwa. Mr. Peter Angubwa, I do appreciate the articulate spirit behind Executive Order RNB number 12 of 2026, and I thank Uganda Law Society, Governing Council for taking this bold step to issue this executive order. Thank you so much, Peter, for that comment. We are very, very happy that you're able to partake of this information and also comment about it to show where you stand. We appreciate, or rather, the Governing Council is listening in from the different platforms that are being used to disseminate this information and create awareness. Thank you so much, Peter. Yes, Mr. Kalali, thank you so much for the clarion call. The members of the public and the members of the bar are all welcome to reach out to members of Uganda society, especially the secretariat, or have reach out to the president. The president is a very, very open door for everybody. You know, he's a public interest litigant. He loves to receive complaints, if not compliments, but complaints especially, because that is how his impact is known. And of course, the president, ISK, Semakade Senior Council, easily delegates and assigns instructions and roles to different stalwarts, like Mr. Kalali Stephen, who has been a very, very, very able representative of the president, as you send him regards. We have another question, Mr. Kalali, from Miss Akankwasa Bridget, who is asking, how can lawyers and the judiciary improve public legal literacy on bail? How can lawyers and the judiciary improve public legal literacy on bail? It appears people don't know so much about bail. I will continue to request you to stick with us and answer these questions, as we are also waiting on to the next speaker who is supposed to be joining us shortly. Mr. Kalali, please.
Thank you for that question, and greetings to my colleague who has sent that question. I believe the best way we can do that is through continuous sensitization. And this goes by, right now we have a problem. I would say that the judiciary sees Uganda Law Society as its co-wife. And yet the society is just trying to execute its mandate under Section 3. That, look here, we are not supposed to leave people in darkness. If you're doing things that are wrong, you're held accountable to the public. But a joint workshop and outreach to the members of the public would have been the best, by the Uganda Society members or representatives and a member of the judiciary. It could be a magistrate or their public relations officer. And this I've always said on some of the talk shows I've appeared to on TV, that the government itself has deliberately failed on its obligation to sensitize the members of the public. We need to go to the grassroots. Now, for me, I would say, as the Uganda Law Society, we have the legal aid. We can always choose colleagues from that department. They go to the grassroots. We come up with more programs, even if it's visual or it's physical interface. We hold awareness sessions and inform the members of the public what is expected of bail, what does bail mean, and what is entailed there in that regard. Just like 2 weeks back, I was on TV and I was explaining that some of the members of the public, why they have challenges with, let's say, cases they report at police. These people, after reporting cases, they are not informed by the police officers that they're supposed to bring people to make statements to support their claims. So they get someone, abandon him at police, because one person has been got as a suspect. This person goes away, police has not guided them, so they end up releasing the suspect, and they say this person paid money at police. So me, I believe we as the Uganda Law Society, since the bench chose to be our co-wives, we can take on the initiative, put it in our annual calendar or quarterly agenda. We reach out to the different regions and we sensitize the members of the public. Basically, I would even say not only about bail, but what is entailed in the criminal justice system, to stretch with when you report a case at police, what is expected of you? Following up with the police, state all that. Two, when the case now is sanctioned, what is expected of you? Even you as an accused, what is expected of you? And this we can achieve through the interested members of the public, or if not, we engage the area LOC chairpersons. They can be of much help in mobilizing, and we can ably stretch this knowledge to the public.
Thank you, Mr. Kalali. You've given us a very big call, or rather mandate or task as the Uganda Law Society, especially operating as the Legal Aid Project, which of course conducts its business in 22 different clinics across the country, ranging from West Nile, Arua, where I come from, Adjumani, Moyo, to Moroto, Nakapiripirit, and Jinja, getting closer to Mbale, to Masaka, Mbarara, Kabale. You know, we are really widespread in our services, and it's important for, as you've said, the continuous sensitization and also embedding our such kind of activities into the annual calendar so that the whole conundrum of criminal justice system is addressed, and not just necessarily bail, which of course is a better way to address the question that Ms. Akankwasa Bridget was asking. But before Mr. Kalali runs away, Mr. Okumu Samson is still on your case as well. He has a question and is asking, or rather a statement, looking ahead, what do you foresee as the biggest challenge to the protection of the right to liberty in Uganda? Looking ahead, what do you foresee as the biggest challenge to the protection of the right to liberty in Uganda? That is from Mr. Okumu Samson. Thank you so much, Mr. Okumu, for reaching out to us. We encourage all the others to also, send in a question or a comment, or in any case, raise a hand so that you can make a comment to what has just been unpacked by Mr. Kalali. Mr. Kalali, please. Oh, we seem to have lost Mr. Kalali, or I don't know, yes, IT, I don't know if you're able to support Mr. Kalali. He seems to have dropped off. Mr. Okumu Samson, you'll kindly help and wait a little bit to get the answers to your question. We also have another question from Mr. Tumushabe Dennis, and then another which is anonymous, but we're going to read a statement from Mr. Peter, who once again has reached out. Mr. Peter Angubwa, yes, my brother, thank you so much for reaching out. Our default Saru, you're saying regarding Executive Order Radical New Ban number 12, Section 4, would it not have been best to complete consultation on the decolonization of court culture first before issuing the EO RNB number 12? All our laws are written in the colonial language of English. Has the Governing Council of ULS considered the costs associated with the effect of Order number 12, Section 4? If the judiciary rejects this order, which will not be a surprise, what practical steps are in place to ensure that the executive order is followed across the country? Yeah, thank you so much, Mr. Peter Angua. We appreciate the question, and we shall hope that Mr. Kalali, who right now, of course, is also a member. Yes, Mr. Kalali, we lost you. I'm sorry. There's been two questions. There's still some questions we have for you, sir. I hope you are able to still stand with us. We are about...
You can actually rephrase for me those questions and I answer accordingly.
Thank you very much. Mr. Okumu Samson is asking a question, and he starts with the statement, looking ahead, what do you foresee as the biggest challenge to the protection of the right to liberty in Uganda?
Well, looking ahead, like I said, my discussion here centers on three things. The threat is, one, abdication of judicial duty and oath we are faced with a challenge whereby, when my liberty is taken away, the only institution that can give me that right is the judiciary or the bench. And like I said earlier on, I think maybe I didn't, in the words of Justice Barbara Jordan, he was the Supreme Court Justice of America. He said that the court has always been the last bastion of the protection of our freedoms. So if the court itself cannot grant me this remedy as obliged under Article 20, Clause 2, it means there will be no hope. So the first threat is that judicial cowardice and unwillingness to administer justice in people's norms as well as their aspirations. Then two, the executive influence. Because time and again, it's not only against the right to liberty, but even other institutions. The executive arm seems to stretch more to the neighbor's plate to consume whatever it can't even take. And now it's high time those people who are the respective holders of those offices to stand firm and realize they have a constitutional obligation and they have to account to the Ugandans. So those are the main two threats I see, and which are actually we can do with them. How? It's not about judicial activism, as I said. Look here, I took my oath. You've given me the phone calls through the Chief Justice or through the PJ or my supervisor at the station or whoever, but I will listen, then I make my decision. If you're not happy, go and rearrest Kizza Besigye if you want. But I know you will not bring him back to my court. So that's all we are looking for. Let's stand strong. We know what justices like Katusu were doing. The Ogoras. Egonda Antenda has just left. He gave a remarkable speech on the right to liberty. So this is what we are looking out for. And I can assure you, members and colleagues online, these judicial officers are there at the bench. It's only an issue to do with a wake-up call within their hearts. Is this a decision I'm making and the public can stand with me in this regard? Self-empathy. So that's what I can say in that regard. Maybe, Jurua, if you may ask another question.
Yes, Mr. Kalali, we got a message from within the attendees on the space of Zoom. Mr. Peter Angubwa was asking a question to do with the EO that has just been read. I don't know if you have any statement to make about it, but of course I also believe that you are perpendicular enough. His statement was reading, regarding EO RNB number 12, section 4, would it not have been best to complete consultation on the decolonization of court culture first before issuing the executive order? All our laws are written in the colonial language of English. Has the Governing Council of ULS considered the costs associated with the effect of the order under Section 4? If the judiciary rejects this order, which will not be a surprise, what practical steps are in place to ensure that the order is followed across the country?
Well, I think, like I said, okay, what I may say in that regard, it's all about, sometimes we need to adopt what they call self-help. Self-help, because like he has rightly commented, the judiciary will reject it unless it's a new judiciary, but the current one will reject it. And we don't expect any change within 1 or 2 years from now. So we shall have to resort to self-help. And the society, as my colleague is asking, we can always look out for people who are willing to stand with us. So we understand our laws are in English. But like the president gave his view, and even Council Salibabu, I've also moved to some countries. You go to Germany, I'm always practicing at the East African Court of Justice. I've been at the South African Human Rights Tribunal. These are entities where you will find even a judge is dressed in a plain shirt, is associating with you. You're not seeing bodyguards all over stopping you or pushing you in the lift to move out. Like, I don't understand. If you're really administering justice, and that's what I say, if you are administering justice, why would you command so much respect from us? Let you, what you do, all your deeds, call us to give you the respect, not you dictating through the heavy whatever's around yourself. So me, I think self-help would be the best remedy, and we see how we can achieve. Because some of these ideologies, the president has brought them, but they will not be achieved within one day. Colleagues, it's all about you and me to always push the agenda ahead. I will borrow from, I may not like whatever Museveni did, but I will borrow some from him. He started it as with these few people. Then others got along and pushed the message. So that's what I would say. Let us be objective in whatever ideology that is being brought, as long as it has some sense in it to push forward the society. Because if the government has failed, it is upon us as an independent bar association to push forward. We have seen the bar association in Kenya, bar association in other countries. They are very independent and formidable. They contribute to policy changes in their respective countries.
Thank you so much. I hope, Peter, you have gotten your answer. That, of course, is an abstract from one of the stalwarts and the brains behind the Radical New Bar innovation of how judicial practice is intended to change, and he is a living testimony of how much policy has changed by way of the radicalism that they are bringing forward, and we, of course, are witnessing that in our lifetime. Thank you. I hope you are satisfied, and feel free to ask more questions. There is a question from Mr. Tumushabe Dennis. He's asking a question about high-profile cases, and he's wondering what lessons can be drawn from recent high-profile bail decisions, and how should the public treat the judiciary in regard to perception. What lessons can be drawn from the recent high-profile bail decisions, and how can the public treat the judiciary in regard to perception?
Well, I would say, what lessons? Personally, as someone who knows constitutional law, criminal law, and all that, I would say, what lesson? They are injudicious decisions. They are political in nature. They are not based on the law. That's what I can say. Like I gave an aspect, I gave you the decision of Vakaluba versus Betty Nambosi. It entails, it clearly discussed Article 28 on a fair hearing. Someone has failed their bail application. The lawyers are incarcerated. Others have been declared persona non grata, and these are the lead counsel. The litigant tells you, my lawyers are not here, and for you saying, no, I'm dismissing this for want of prosecution because I believe there are other lawyers who ought to have come. As a lawyer, we have an obligation under the Advocates Professional Conduct Regulations. Regulation 2, I cannot stick to a case that I'm a lawyer of sworn. So when they have not instructed me, and this is what Dr. Kiza Besigye said, that some of the lawyers you saw here, we were surprised to see them, but we had never instructed them. My lawyers are so and so. So if they are not here, you cannot tell me that you're dismissing my matter for want of prosecution. So such a decision, in my view, I would say it was injudicious, and I would take it that these are the contradictory decisions we are having. So the lesson is, we have gone away from the respect of the doctrine of precedence, or stereodesis, as we may take it. I cited the case of Tumushabe versus Attorney General. It is clear on the right to liberty, and this is a petition that went up to Supreme Court, and they upheld the concept on the right to liberty and recognizing bail. So me, I would say there is no serious jurisprudential lesson we can get from that. Personally, I also filed petition number 32 of 2022, challenging the constitutional bail guidelines on usurping the powers of release on mandatory bail from a magistrate court. The Chief Justice trying to amend the Constitution. by giving the powers to exclusively High Court and making someone be detained for more days past the Constitution 180 to stay in custody pending determination of that. That petition was had 2 years back. Like they always hide under judgment or notice, it has never been delivered, the decision. So these are lessons, and these are some of the petitions that could give us more light and understand what really is the problem and how best can we go about this. I just want our colleagues to understand, like in that precept of bail, we have the constitutional bail guidelines, but some of the provisions therein actually, they are contradicting or inconsistent with the statutory provisions in the MCA. And there is already a remedy, but some judicial officers seem not to see it. Because Section 18.4 of the Interpretation Act is clear that where an SI or a secondary legislation contradicts the provision of the mother statute, it's null and void to that extent. So you're just supposed to revisit. But some of our judicial officers, with respect, I've said some, it seems they are reluctant to research, and some are not willing to adopt or understand the precedents already on record that we have in this country that have a very good jurisprudential value. So my lesson is contradictory decisions that are injudicious.
Thank you so much for those answers. I don't know why, but today we have so many questions. You'll have to bear with us. I think people are very attentive from what you shared earlier on. They're very inquisitive. One, Tusubira Alvin Kate. Miss Tusubira Alvin Kate is asking how should courts balance the rights of the accused against the interests of victims, witnesses, and society. How should courts balance the rights of the accused against the interests of victims, witnesses, and society?
Well, that's a nice question. And the bail guidelines do provide for it as well as the Constitution itself. How? If Kalali or ex-Besigye has applied for bail, how best can I balance this? Give them a release on bail on such reasonable conditions. For instance, if you're saying the victim stays in Iganga or on a particular village, Kawempe or LDC, Mr. Kalali is suspected to be also staying in the same vicinity. Just put stringent terms. Mr. Besigye or Mr. Kalali, please, we shouldn't see you such and such meters next to the suspect. We are granting you bail on deposit of the passport here. We are granting you bail on such limit as to terms of movement. There you have balanced the interests of the accused as well as the state. But if you say your remedy is in continued detention without trial, like I said, Article 28, which envisages the right to a fair hearing and allowing me prepare for my defense and all that, we all bear testimony. At the police, no suspect is allowed to bring any witness to record statements in favor of their case. Once a suspect records a statement, the file is taken to state. So if it's taken to state and sanctioned, the best way of balancing these rights, grant this person privilege to go out, also be liaising with his witnesses and see how best to prepare for their defense. And above all, as I said, the interests of the state do not only stretch to the complainant. If Besigye has a family, has children, those are also lives that the state is mandated to protect. Now, if these people are dependent on me, and you as a judicial officer, you cannot stretch your point to have the Solomonic judgment. I refer to King Solomon, the wise decisions he used to make. If you don't have that Solomonic judgment and Miller syndrome in you, you will not be in a position to understand that whereas the complainant is here, I have to balance their rights. I also need to have a bigger picture and balance both parties' rights. And that's best in the conditions of bail, which you can make, that let him deposit such and such an amount. you're subject to these limitations. Even by the way, court, if I don't have a fixed house there, can also give condition that Mr. Kalali, don't go back to Kawempe, you should shift to another residence. It's possible.
Yeah, thank you so much, Mr. Kalali. You've done justice to all of these questions. And I know you already intimated to us that you were having a journey, you were already out country doing some work. We don't want to lose the concentration, but also we don't want to take so much of your time. We have a last question here coming in from one Abeja Doris. Thank you, ladies and gentlemen. We are so humbled by your questions because they, of course, also lend credit to what has been discussed. And it also shows that we are attentively listening into these very, very intriguing discussions. She is asking, how does prolonged pre-trial detention affect the presumption of innocence? How does prolonged pre-trial detention affect the presumption of innocence?
Well, prolonged detention, how it affects the presumption of innocence is one. In the line of, it's like someone is already adjudged guilty. As I've said, some of these cases, they take long to be even cause listed for sessions. And that's why you've seen previously, the Ugandan society has always prayed and confronted the bench. Let us abolish the aspect of session hearing in the criminal justice system. It's not legally provided for. There is no statutory provision to that respect. Let us have cases, daily sessions. And this can be achieved through the Chief Justice and his team engaging Parliament and the government to give them funds. So prolonged pre-trial detention, that's how with the presumption of innocence in a way that one, someone is already like adjudged guilty. And this goes with the fact that if I've spent over 10 years on pre-trial detention, no bail, no what, some of these people are the ones you're seeing going for plea bargain. Not because they are willing or they understand the plea bargain, but because they are saying, let me just go and I see if I can go back home. So someone loses it all. They lose even an idea about getting a fair hearing. Some of the witnesses you may have had, they have already died. So that's how it affects the presumption of innocence. If you had a witness who is Kalali, and the gentleman has spent over 20 years. We saw someone who had spent 25 years in Lusita without trial. 25 years. If the witness you had was Kalali and the age is 75, he has already passed on. So are you still innocent in absence of any witness on your side? That's how it goes out with the presumption of innocence. And it's why we constitutionally say, let us have a speedy and expeditious trial, but not the Okero, speedy, and the mob justice.
Wow. Thank you so much, Mr. Kalali. You have been very, very eloquent in your deliberations, and we have had a very fair test of the members' questions, which, of course, as we said before, lends credence to the talk show or the engagement for us, which it already puts a lot of smiles on our hearts. And we are grateful that Mr. Kalali has done justice to the questions that have all been asked from the people who sent in their questions. We had a question from Bridget, we had one from Samson, we had one from Tumushabe, we had one from Tumushabe and one from Abeja, and some comments and questions from Peter. Thank you so much for doing that to us. We need also to maybe bring to your knowledge for those that might not be informed. I don't know, Mr. Kalali, if you're privy to this information because it came in while you were making a presentation. The Honorable Mwanga Chivumbi has been granted bail after we all know it has also been another thorn in the skin. There's been continued pleas and applications for bail from Butambala stemming from the general elections that were conducted on the 16th of January. Uganda Law Society, and particularly myself, I was able to be a part of the defense counsel that was applying for bail for so long a time. until very recently, of course, that the Defense Council continued to apply. And as we were on this call, Mr. Kalali, we have gotten information as breaking news that Honorable Mwanga Chivumbi and the 24 others have been granted bail, and we would like to use that information to invite you to comment about it. I know you don't have the details, but we have just been shooting down the government and the state and of course the judiciary for their lackadaisical behavior. But here we are getting some relief in news that the Honorable has been given bail.
Yeah, my point on that, of course, personally, when I saw, I don't know, unless they changed, but I got information. The judicial officer who was handling the bail application, I think that was Justice Susan Okarang.
Yes.
I personally know her, and these are the few I told you who are in the judiciary that are willing to uphold their oath. So I had no doubt in her. And that's why you saw the state, through its vindictive nature, they decided, even the Dr. Kiza Besigye, deliberately not to take it to the ICD, because they know there are some independent judicial officers who can exercise their right to grant bail. I will tell you, there are some FDC people who were arrested first before Dr. Besigye. They were taken to ICD. So the request was made to have Besigye go there. The state deliberately said, no, we are keeping him here because this is one high court. So kudos to Justice Susan Okarang. At least I know her personally. And she has been a former state attorney under DPP's office. She knows what she did and she knows what she does. She's someone who believes in her faith, just like Atim Gloria. Such judicial officers, I can tell you, in this era we are in, need protection. They need our prayers. And they need to be saluted each and every day. They make such Solomonic judgments. I appreciate it, and our brother Mwanga Kivumbi, welcome back home. We hope the junta won't arrest him again, and they put more charges on his head.
Thank you, Mr. Kalali, for the flowers that you've given to the judge and the magistrate. It is also necessary to give respect and credence where it is due, because they are human beings just like us, and they need to be given a pat on the back when they do the right thing, in light of the fact that we are facing a challenge of very many of them who are doing the opposite, which of course is a place where we are, a very unfortunate place to be, a very gray area in the judicial practice of Uganda, which leaves so many lawyers, over 7,000, as the ULS has in records, to be in a place that cannot be fathomed at all. Yes, thank you so much, Mr. Kalali. You've ably answered that question. And of course, it gives us a little bit of a smile to know that there is a victory that can be registered amidst the hardships that we are facing. The ULS was part and parcel of the Defense Council of that matter. And we are giving credit to the leadership, of course, of Isaac K. Semakade, Senior Counsel, who guides us on how we should go about these matters. Amidst all the other work that is being done by the Ugandan Society and the cluster that involves Mr. Stephen Kalali, that of course is in the litigation department. We are very grateful for all that you're doing. Thank you so much. Mr. Kalali, we are coming to the end of this session, as we request that you maybe make your closing remarks and your parting shots so that you can go into your other work. We are very grateful and honored that you've been able to join us, but if you could kindly give your closing remarks so that we can find a way to close the session. We have not been able to have the presence of Mr. Godber Tumushabe, who of course is a very respected senior citizen in these aspects of discussion. We had earlier on had a discussion with him. He said he was quite engaged, as very many of them are, just like Mr. Kalali, and he said he would join us a little bit inside the session, but efforts to get to him have not been possible, and we don't want to hold our members who have busy schedules listening into this discussion. And yet we've also had a very, very eloquent guest speaker in Mr. Kalali to unpack the discussion. So we'd like to ask that Mr. Kalali shares with us his closing remarks, and then we can find a way to close this session, please. Mr. Kalali.
My parting remarks, first of all, I would like to appreciate the President Uganda Society and the council members for having seen the viability in me and my colleagues and appointing us to constitute the Section 3 committee, Section 3C committee. I really appreciate that. Two, the members who have been online from the time the session started up to now, it's not easy. Today is a working day. You people have courts, you have offices, you have works to do. That's something that is encouraging and mind appreciative. We really appreciate that. Thanks for giving us your time to stay tuned in here and we discuss on some few aspects. As a way of parting, I would say, colleagues, we are lawyers. The profession as it stands, it can only survive with unity. If we are disgruntled in this unity, we shall not achieve and our profession will go to the waste. Let us stand in solidarity. Rule of law in Uganda is not all about Semakade, is not all about Kalali, is not all about Salibabu, is not all about Elias Lukwago. You will keep quiet as you're zipping, and tomorrow the same injustice will knock on your door. If we don't form an army, we can have differences in whatever way we may have. The way Kalali dresses, the way Juro dresses, but let us have unity on one voice, rule of law. Because without the law, our profession is gone. And this is the same message I sent to the members of the bench. Wherever you cross to that state, the oath you took to administer justice in our name and without fear or favor should always remind you that when you retire from that side, you will always be a member of the Uganda Law Society until you get to the grave. And even when you go there, any of your relatives who will ever be asked, they will say, first, on his CV, he was an advocate and a member of the Uganda Law Society. Let us always have this at the back of our minds in the decisions we are making. And that should guide you where you're going off the bench. The public, some of the decisions you're making, are they the decisions you would love even tomorrow as you're going for a burial ceremony? Can you go there without security escorting you? Now, if you're going with security, it shows you yourself, you're also burdened by your injudicious decisions. This is not the kind of life most of the judicial officers we are seeing who are retiring had aspired to. They went to the bench to serve. They were driven by the sense of serving justice. The state prosecutors, kindly, colleagues, our brothers and sisters, let us not continue or be used as persecutors. You're prosecutors, not persecutors. But you are busy sanctioning files against we, your own brothers, on vexatious charges. And that's why I said last time when I was on X in my presentation, we as lawyers, it's high time we stood firm. Colleagues, I repeat, it is high time we stood firm in unity. When a prosecutor sanctions a fine and it is dismissed on no case to answer, let us just prosecute that person. Sue him individually. They are liable. Article 173 cannot save them. If you sanction a vexatious charge, you can be prosecuted individually. This is the only way we shall work or put some sense in some of our brothers and sisters who are on the side of the office of DPP. So with those remarks, I still salute Justice Okalang, Atim, and the rest. I know Justice Mutoni Margaret is also there now. She was taken to family division. Always kudos to her. Colleagues, have a blessed day, nice weekend, and I hope you've garnered some knowledge in the presentations we have had. Don't forget the principles I cited. I'm not commanding you. Please visit them. Look at the UN basic principles on the role of lawyers. These are things you learn to appreciate. I know, I just don't want to preach Jesus' gospel to a Muslim because a Muslim doesn't believe that Jesus was born by God or is a son to God. So that would be preaching Jesus' gospel to a Muslim. Kindly visit these principles. They are often strange or alien to you, but they have everything in content. Thank you. Have a blessed day.
Oh, wow. Thank you. Thank you. Thank you so much, Mr. Kalali. You have surpassed expectations. We cannot thank you more. And as we come to a close of this edition of our R&B Weekly Hybrid Press and Public Engagement, it's my singular honor to extend our very, very, very heartfelt appreciation to you and everyone who has made today's conversation both meaningful and very impactful as we had anticipated. And of course, it goes without saying that the first person to appreciate is Mr. Kalali, with very sincere gratitude, and all the land advocates who have contributed to this very important discussion. And Mr. Kalali, your session today round has been a learning session. You've taught us so many things. You've left us with a lot of research to do, particularly surrounding bail, judicial independence, and administration of justice. You quoting from various cases and international instruments, including the Constitution, of course, that is our grand norm. We want to thank you for the things that you have told us and the principles that you have asked us to go back and look into to become better lawyers. And I think the biggest of all you have helped us to appreciate is we need to stand tall in unity together in order to walk one voice. And of course, I would like to thank every participant in the room that has been with us. It's been an easy 3 hours. It's been 3 hours of continued learning and information appreciation, which of course leaves us very much better lawyers. Of course, we'd like to appreciate the leadership of the ULS, the Radical New Bar Governing Council, under the leadership of Isaac K. Semaka, the Senior Counsel, and of course, Mr. Babu, who was here with us earlier on, but had to run to attend to other matters which are very equally important. So yes, thank you so much. The Radical New Bar remains a testament to the society's commitment to public legal education and constitutional dialogue through such kind of platforms like the Radical New Bar Live Weekly Public and Press Engagement. And of course, all the other people, the communication and technical team that has made this possible. We are having a lot of this online. It's been an online session. Mr. Kalali is far up country. You can't imagine he has been speaking all of this and not necessarily physically present in the room. We've always been online using other platforms, but this time around, all of us, as you can see in my background, I am working remotely, and it has been a tenet of digital transformation that has enabled us to hope to make this possible. And of course, we would like to hope that today's discussion has contributed meaningfully to the ongoing conversation of the President's State of Nation address. And we hope that each of us will learn to champion constitutionalism, judicial independence, and very, very importantly, what we are looking for as we grow into the aspects of rule of law. And on behalf of the Radical New Bar and the Ugandan Law Society, I thank you all for your time, for your participation and continued support. There is a last quote that I have here from Dr. Kiza Besigye that says, "When I set out to the dictatorship, I knew I will have two homes, one that I built myself and the other prison." Very damning statement, but of course it's reflectionary for us to know that to benefit and gain out of our struggles, we need to sacrifice. Dr. Besigye has been in prison for the past coming to 2 years now. He hasn't seen the walls of his home that he built or his house that he built. So that of course means we need to reflect and be able to help each other grow together. There is a statement from a land scholar that says, "A society committed to justice must be willing to question power, defend principle, and trust institutions created by its constitution." Robert Benonjurua from the Rule of Law Department, I would like to thank you so much for giving me the opportunity to host this show. And I would like to appreciate Ms. Afra Pio, Head of Department, Ms. Gwenny Patience, who is a research officer in the Rule of Law Department, for the continued efforts that we have put together to deliver such a very wonderful talk show or engagement. We thank you. We hope we can see you again next week, same time, for another intriguing discussion.